Hello and welcome to On Air with Aashka. Today we are joined by a celebrity lawyer, Vibhav Mithal. Vibhav Mithal is an AI and IPR lawyer and an associate partner at Anand and Anand. He was part of India's first AI and personality rights case, like the Anil Kapoor case, and he was part of the team that secured country's first software patent. Named a rising star by managing IP consecutively for 3 years, he has also co-authored with NASSCOM the Developers Playbook for Responsible AI in India as a part of India's AI mission. To shape the AI ecosystem, he is affiliated with the Center for Responsible AI at IIT Madras for Humanity and RIMAS. As an AI expert, he has also represented India at the Quad Critical Emerging Technology Forum in Japan alongside experts from US, Japan, and Australia. In this episode, our celebrity lawyer Vibhav takes us behind the curtains of the landmark Anil Kapoor deepfake case. He reveals the AI copyright trap where proving infringement requires explaining complex AI processes to judges who may never have used ChatGPT. From Bollywood personality rights to practical advice for everyday citizens, Vibhav challenges conventional wisdom about who is really responsible when AI crosses the legal line. Come join us as Vibhav unpacks India's approach to AI regulation and shares secrets on protecting yourself in a world where the line between you and the AI-generated you grows thinner and thinner every day.
There is a different aspect when it comes to training, and there's a different aspect when it comes into output. When we're talking about taking copyright protected data at the time of training an AI model, and if you've taken some copyright protected work, you put it in your training model, and if you end up reproducing that copyright protected work at the time of training, then it's possible that you may be engaging in copyright infringement. Anil Kapoor case by itself was very unique because you were enforcing personality rights. Why would the tool create an output around Anil Kapoor if there was no input provided to him about Anil Kapoor? When you're talking about protecting yourself against these kind of deepfakes, first aspect is, are you aware about what data are you putting out? That's one thing that starts with you. There's no information right now about India wanting to adopt Pure AI Act, right? AI regulation therefore has to be seen in 3 ways.
Historically, India has played a role of a teacher or a guru to the world. So how can we use those transferable teaching skills that India already has to make today's India more AI literate? Recently, I came across this paper, and this is very much related to the work that you are doing, called AI Copyright Trap. And I found this very interesting statement. The problem is not that AI models are being trained on copyright works without their owner's consent. Then requiring copyright owner's consent and or compensation for the use of their work in AI training datasets is not the appropriate solution. And if the only real copyright problem is that the outputs of generative AI may be substantially similar to specific human authored and copyright protected works, then copyright law, as we know, it already provides the solution. And I remember while signing off 2024, you had written a LinkedIn post outlining something similar. So what are your thoughts on this AI copyright trap? And also, will this trap be as relevant in the agentic AI age that we are entering into as it was in the generative AI age?
Right. That's a good question. See, the first point that I want to highlight in this, and if I've understood the articulation correctly, right, is the AI copyright trap is explained as if that it all that matters is at the output stage, and you're only assessing whether it's substantially similar at the stage of AI output, right? And there seems to be no issue with at the training stage. That's what the articulation appears to me from what you sort of explained it, right? So
yes,
that's how I also, that's why I'm just trying to formulate or sort of conceptualize the copyright trap. Okay, first there are 2 aspects to this. There is a different aspect when it comes to training, and there's a different aspect when it comes into output. So both are different levels of adjudication, right? So training will have a different, so when we're talking about taking copyright protected data at the time of training an AI model, and if you've taken some copyright protected work, you've put it in your training model, subject to whatever technical aspects they have to operate. And if you end up reproducing that output while at the training, sorry, if you not output, if you end up reproducing that copyright protected work at the time of training, then it's possible that you may be engaging in copyright infringement, because you're taking a copyrighted work at the training stage and you're reproducing it, you're storing it or reproducing it at the time of training. Now, this is a possibility, right? So the first point is we have to distinguish between using copyrighted protected material at the time of training versus whatever copyright protected material you see at the output stage. I'm right now only at the training stage. The first point that I made was about the fact that storing and reproducing something that is copyright protected in training data. Now, if you look at some of the licensing terms, the manner in which companies store and train and they use copyright protected material on, or if they use it at all, if they're using copyright protected material at the time of training, there are descriptions by certain providers there which say that at the time of training, the training information that they're using, they are not storing and they're not reproducing the training content. So now if there is no reproduction or if there is no storing at the time of training of an AI model with copyrighted information, if there's no storing, no reproduction, where is the infringement? So the post that you're talking about is that I have to, this aspect, whether at the time of training of an AI model there has actually been copyright infringement, which is the reproduction of copyrighted data, any of those matters, then it becomes a situation where you have to look at, I mean, whether there's actual reproduction or not, whether infringement is happening or not, requires a understanding of the technical process in which an AI model is trained. Which data did you take? Why did you take it? Once you trained it, what is actually fed to the model? What does the model store? What does the model reproduce? Is that the actual copyright protected work? Is that something else? Those aspects have to be examined. That's at the training stage. That's one aspect. If we come to the output stage, right? So yes, if I can understand how the copyright trap was made, but the aspect is that, of course, when you have an infringing output, by looking at the infringing output, were you able to identify that your copyright protected material was taken at the training stage, right? So the only way you make out, the only way that you make out that there has been infringement is when you check the output of a generative AI model and then you see that the output is reproducing something substantially similar. And at that point of time, you come to a conclusion that your copyright has been violated or your IP has been violated. So when we come to the adjudication on the copyright aspect, again, it's an extension of the same thing. So for example, what happened at the training stage, when we come to the output stage, we have to look at, again, then it's a question of after training, how is the model retrieving such information, right? And the manner of retrieval of that information, is that amounting to infringement of copyright? Is what is stored in the model or how the model is operating, is that the copyrighted work? The way it is retrieving and the bits and manners it retrieves the information to create the output, is that retrieval infringement? Because of course the output is substantially similar. So the plaintiff will obviously make a claim, and it's obvious as per current law that if it's substantially similar to my copyright protected work, I'll make my claim that my copyright has been infringed. My post was more connected about the fact that if the defendant has to make a case or if has to make a defense, then this entire technical process of the way the model is trained, from the way the model produces an output, has to be explained, right? And if we add the aspect of agentic AI to this, right, so that obviously agentic AI is only a model that is performing certain tasks simultaneously. So if I might only have a text generator and it can do, I give a prompt and then it in an output generates a text and a response. Agentic AI would be doing multiple things at the same time and the model be doing multiple aspects, but the base of it could be from data that it has been trained on. And it's possible that while combining and participating in those multiple activities or carrying out those multiple tasks, the output by itself could be infringement, could not be infringing. It's very difficult and too early for us to come to any conclusion whether it will not throw out an infringing output or it will not throw out a non-infringing output. Right? It will throw out an infringing output or non-infringing output. And again, even in agentic AI, my claim would only come from the basis of the output. That again
Got
goes back to the same question that if a claim is made against an agentic AI, how do we in any manner
trace the and
how do we trace, how is the model trained, whether there was reproduction or not, whether there was storage or not, without the explanation of those technical aspects in non-technical terms in a way that judge can understand, without arguing that before the court. It is very difficult at this point of time. It would appear just from this review of the outputs that copyright and rights are being infringed.
got it. Got it. So, how easy or hard, or maybe how well is the legal system? Of course, you must be more aware of the India scenario. Like, how is the legal system equipped to kind of consider or judge these kind of cases? Like, are they well equipped, or what is the current situation in the legal system?
I think the legal system is very well equipped. So, for example, we practice in the Delhi High Court. Intellectual property right litigation has been happening here for many years. There's an
Yeah.
appreciation of various types of technology, patent law. In
Mm-hmm.
patent law, different types of patents could be pharmaceutical, could be mechanical, could be agri-biotech industry, right? So,
Yeah.
the courts definitely appreciate these issues. But what I'm trying to highlight here is, in addition to judges, it is also the responsibility of the counsels and the lawyers arguing
Mm-hmm.
these cases to be able to put their points in a way that can also assist the judge in understanding the technology clearly in terms of what is happening,
Yes.
right? So
Got
it's
it.
sort of it's an effort from both ends, right? And
Yeah.
judges are obviously very receptive, so they understand these aspects. I mean, for
Hmm.
example, if you look at the Supreme Court decision on Puttaswamy, which is the one that declared privacy as a fundamental right, way
Mm-hmm.
back in 2017, the court has observations on informational privacy where they spoke
Mm-hmm.
about data protection, right? So the point is, and the court was very cognizant of the how you leave profiles on the internet and how your information that you leave behind gives detailed information about you. So courts understand these aspects, but when it comes to a specific case, it is the responsibility of the lawyer to
Mm-hmm.
take you through that. So the
The
plaintiff will
technical
have
aspects.
exactly. I mean, whether
Got
it is to prove your case or whether it's to defend the case.
got it. Got it. So, like for lawyers as well, AI literacy is very important who are
Correct.
fighting these kind of cases. Got it.
Correct.
Got it. Makes sense. Yeah. Yeah. So, let's move to the next question that is kind of related to this one. We all saw that in Times 100 most influential people in AI, Anil Kapoor, our distinguished Anil Kapoor was featured, and most of the Indian audience was kind of surprised why his name came on that list. And of course, because of the cases that he dealt with regarding deep fakes, his voice or the famous dialogues were kind of used by the deep fakes without him required. My question to you is, are there any existing laws or policies in the Indian context that are strong enough and accessible enough to protect any ordinary Anil in our country, and not just Mr. Anil Kapoor, because he had, of course, access to the best lawyers and the best everything in the country. So, yeah, are there any existing laws? And the other thing is, can you outline any steps that an ordinary Indian should take if they become a victim of these kind of disturbing deepfakes or themselves? Yeah.
So I think first of all, I'd like to thank you because the point is that we did the Anil Kapoor case. Our firm filed
Oh,
it.
okay.
We
Perfect.
we worked on it.
Perfect.
I worked on the plaint.
Okay.
I'd worked on the
Then you are
claim.
a celebrity lawyer.
We'll come to the next part of the question as well. But the Anil Kapoor case was in September 2023, if I remember it correctly. It was very consciously drafted. It was also different from the various. It was very different from the other cases that were there at the time in the US. Because
Okay.
at that point of time, we were in September 23. So if I remember correctly, because I was working on I was working on the case at the time of filing the suit. I remember that we only had people making claims on AI outputs in the copyright space. There weren't any personality right cases. So Anil Kapoor,
Yeah.
the case by itself was very unique because you were enforcing personality rights. Then the other key aspect, of course, the matter is still sub judice, but the key aspect about it was that because the generative AI output was infringing upon his personality rights,
Hmm.
which is a clincher here because he's a famous personality, it is
Yeah.
obvious that whatever input that would have been given to the tool would have involved using some aspects of his persona, right?
Okay.
Why
Yeah.
would the tool create an output around Anil Kapoor if there was if there was no input provided to him about Anil Kapoor? So,
Got
so
it.
that makes that case by itself, first of all, very different from all the cases at that time in the globe, right?
Hmm.
Anand and Anand and Nayak sort of did that case together. The
Yeah.
Bombay and the
Yes.
Delhi team who did it together,
Got. Yeah.
and so that case was different for that reason. So yes, so it obviously laid down a series of it laid down to how to protect personality rights through generative AI tools. And then we had the Jack Shroff case after that, and the Vishnu Manchu case after that on personality rights protection. That's one component. Now coming to your question of protecting a normal Anil and what steps can be taken. The first aspect that is really important, and this goes back to something that I was discussing just yesterday, which is known as how to control your data. Yesterday, the day before was data privacy day, data protection day, and
Yes.
we had another panel yesterday
Hmm.
around that, right? And the main point that has to be remembered here is that when you're talking about a common person protecting yourself against these kind of deepfakes, first aspect is, are you aware about what data are you putting out? Are you
Got it.
aware about what is exactly happening in terms of the data that you're putting out? For example, your senses, let's tie it to senses. What do you see? You see on Netflix, you choose a movie, you select
Hmm.
a movie, that is a data point. What you're
Got
listening
it.
to music, that is a data point. What when you're touching and you're using sense of touch, so using your phone and you're sort of scrolling through social media, whatever you like, that's a data point. So when you're talking about deepfakes, one of the things that you have to talk about is what are you putting out there in the public, which someone can use being in public domain, which could lead to making a deepfake. And I mean that in the sense that when you're talking about a normal person, we're talking about, children, or we're talking about a particular age group of teenagers, right? So you have to be
Yeah.
first, you have to be aware. That's one thing that
Yeah.
starts with you.
You.
What are you doing, and how are you looking at this space? I mean, if you're not conscious, you're not aware, awareness is the right word. If you're not aware of what you're doing, then these situations can play out. That's one aspect. The other aspect is that if does, God forbid, something does happen, then we obviously, okay, then there's the other aspect, right? Then there is, if something does happen, there is the information technology rules, which is often invoked in this space about Rule 31B of the Information Technology Act, where intermediaries are supposed to inform their users through their privacy policy, user agreement, not to upload any material that is, defamatory or derogatory, or that it violates anyone's IPR rights. So there's one sort of mechanism that's coming in. So one mechanism is you. Second mechanism is an intermediary that is informing you through its obligations about what you're not supposed to do. Third
Got
is that
it.
if you are involved in deepfake, if you've got a deepfake, then currently you obviously have criminal laws that come in. So you will have a combination of your erstwhile in criminal law, Indian Penal Code, erstwhile in Penal Code, with the new law that is there, the provisions around cheating, forgery, cheating by personation. Combine that with, say, the Information Technology Act, right? And you could probably file a criminal case. Alternatively, depending on the nature of the case, you could also, I mean, for example, if a deep fake has been created and you're being defamed for that matter, then you have a civil action for defamation.
Okay.
So, I mean, there are options available. It,
Got
it
it.
it it requires us to understand what are the facts, what are
Hmm.
the what will apply to you,
Hmm.
and then finding a solution around it, right?
Got it.
So, but I would again re-emphasize that if you're concerned about deepfakes, you also have to also be careful about what you're doing. And of course, for material that is already out there, then
Hmm.
it's a question of probably criminal enforcement,
Hmm.
otherwise civil enforcement. Criminal
Got it.
enforcement, people tend to prefer more, sort of has a more immediate impact, but even civil litigation is a good option because, I mean, Anil Kapoor, Jackie Shroff,
Amitabh
Vishnu
Bachchan
Manchu,
and
Amitabh
okay.
Bachchan, all of them are from our firm only, from Anand and Anand. And the
Okay.
point is that you have to also get correct counsel about this, right? So it's just
Hmm.
because those people took the step to come to court. If someone else takes
Yes.
the step to come to court, we can probably find a solution.
Yeah, yeah. So mostly ordinary people are just ignore and just leave it to the fate. Like, okay, this has happened, and like, let's not get into these judicial battles because it will take maybe a longer time to get justice. So that is why I brought up this question.
Of
That
course.
you are protected and you should utilize these laws in your favor and protect yourself in this AI.
Absolutely.
Yes, yes. So, talking about the AI regulation, of course, you mentioned a lot of laws that are not AI specific or AI regulation or anything such, but it kind of protects people in this AI age. But I would like to know more on the scene of AI regulation in India. Of course, there are other laws that are reusable, but like, is India planning to have any kind of specific AI regulation like the EU AI Act, or how is it approaching the AI regulation in this age?
Right. So one of the things that, and I remember this from even when we were discussing this way back in 2021, and we had some
Mhm.
regulators in a panel, right?
Mhm.
And these are regulators not from India but from foreign countries.
Okay.
Those regulators uh, spoke about the fact that it is, before we sort of recraft anything new, we must understand what we have in hand. Even
Yes.
if we don't, there's no information right now about India wanting to adopt a pure AI Act, right?
Yeah.
But that said, it is also equally important for us to first adequately assess what current laws apply to AI. For
Mm.
example, we've written a book chapter on AI law review for edition 1 and edition 2, which lay out some current laws that apply to AI, which would be like your Digital Personal Data Protection Act on the personal data protection aspects will cover AI. To what extent, what is the gap, we can discuss that, but it'll cover. We've invoked intellectual property rights. We just spoke about Anil Kapoor, Jackie Shroff, Vishnu Manchu, which
Yeah.
covers AI. We have consumer protection acts, which has an aspect of product safety, product liability, that has been brought in the Consumer Protection Act, which means if there's a defect in any product, you can bring that, take an action on it from a consumer protection lens. We've spoken about laws, criminal laws around deepfakes or intermediary obligations. So the point is that a mapping of current laws to the manner it may extend to AI is also a way that you have to look at this field. Expecting
Yes.
that everything will be put in one entire bucket may also
Mm-hmm.
not be the right way, because that then
Way.
leads to a all or nothing phenomena.
Got
Understanding
it.
what current laws apply to AI would help us. Then trying to see where there are gaps, I would understand that. But we obviously have to first take the current laws and take them. And we've also had the AI governance guidelines. I think draft AI governance guidelines that have been issued by the government of India, but in the chairman committee, there's a governance guideline that's been issued by a particular, I think
Yes.
from the principal scientific advisor body, it has come out, right? And they're still
Yeah.
in the draft stage. There, I think the inputs are coming in till 27th of February, if I'm right. So the
Mhm.
point is that even that report lays out certain current laws that apply, right? So
Got
that's
it.
one aspect. What about current laws? Then, in
Hmm.
addition to that, I think I'd like to bring in that, of course, there
Gaps.
might be certain aspects and certain concepts in AI, like we discussed initially, like explainability and transparency or human oversight aspects, which may not be covered in current laws because they're not AI focused laws. Then, in
Yeah.
that scenario, in my mind at least, we also have the value of voluntary frameworks, right?
Yeah.
Voluntary frameworks could be by an organization, could be by an
Hmm.
industry body, but voluntary frameworks sort of bring in a certain level of touch to technology with a particular perspective or a particular perspective and particular approach to how steps can be taken. And voluntary is obviously voluntary in nature. One example I can cite,
Yeah.
of course, is that there's a playbook, a developer's playbook that we developed with the trade body NASCOM, right?
Yeah.
Which was released late last year, which is developer's playbook
Yes.
means it's intended for the technical audience. It is intended for the technical individual in the organization. And with that, with a particular AI lifecycle approach, you look at the AI lifecycle, and then you look at the steps that one has to take, an engineer may take to achieve actionable steps in responsible AI across that entire AI lifecycle, right? in that scenario, what ends up happening is that you have a situation where you've at least articulated from an industry standpoint what steps do I need to take within each AI type. So just to expand that a little bit, we've identified four stages of AI life cycle: development, pre-development, then collection of data, then the entire aspect about building the model, and fourth is about once the model is built, it's out in the
Deployment.
market. And then we had three AI types: discriminative AI, which is your normal machine learning pattern recognition tools; generative AI, the more creative output ones; and then you had AI applications which were built on top of discriminative AI or generative AI. So we had those 12 silos. Now
Okay.
this is just an example of a voluntary framework, but what it does is that it's built by a trade body, it interacts with various startups, it's intended for the technical audience, and it allows you to think through what obligations and what steps you need to take. And that got endorsed by the Indian government, and it's part of the safe and trusted AI pillar of the Indian government. So why that is helpful is that AI regulation therefore has to be seen in three ways. One, what current laws exist. Two,
Yes.
what do current laws miss? And if they're missing something, do I want a legally binding obligation to it? And third, the voluntary aspect to it, the
Yeah.
voluntary framework aspect to it. Of course, there's a lot of debate about whether self regulation really works, doesn't work.
Yeah.
But the point really is that if you don't have an obligation and if you don't have a legally binding obligation imprinted to you by law, but you're already working in that space, will you not take steps to be proactive? If you are going to be taking steps to be proactive, will not a voluntary framework in that space help you? At least it will have a certain level of credibility, it'll have a certain level of perspective, it'll have certain guidance. Obviously, the fact that it's voluntary, if you go wrong, you're not penalized, but it at least gets you started. It gets you started.
Stuck.
You're not stuck, you're not static,
Yeah.
and you can move on. I mean, that's how I look at this space. Rather
Yes.
than worrying out, one of the main concerns on self-regulation is that if you go wrong, you only get a rap on the knuckles and nothing else happens. But I
Hmm.
look at it the other way around, that if you want to comply, at least you have something.
Yes, yes, yes. And it helps build trust also with the customers that they are working with, that they are abiding by these voluntary or the self-regulatory schemes given by the government of India itself. So, yeah, it is helpful. Of course, reputational damage no one wants in this
Exactly.
fast-paced AI age. So, yeah, I agree.
Exactly.
Mm. Yes, let's move on to the next question. Historically, India has played a role of a teacher or a guru to the world in terms of spiritual wisdom, etc. So, how can we use those transferable teaching skills that India already has to make today's India, more AI literate? Me explain AI literacy for my audience. The ability to understand, use, monitor, and critically reflect on AI applications without necessarily being able to develop AI models themselves is referred to as AI literacy, as quoted in your report on the United Nations called Digital Literacy: The Great Divide. So, what's your take on like how can we use those teaching skills that we already have to make India more AI literate? What's coming next? We will dive into the AI literacy challenge, explore the future of AI governance, and much more. Please do like, share, comment, subscribe, hit the bell icon, and make the YouTube algorithm happy. And help us build an informed community that is excited about AI's benefits while staying aware of its risks. Stay tuned for the final part of this episode. This is Ashka signing off for now. Let's ride these airwaves again soon.